I'm Danielle Mciver, Chief Product Officer for the Family Office. I'm focusing on our offshore products, and I'm pleased to bring to you the first webinar in our offshore series. I have with me Angela Calnan, a partner at Collas Crill, an offshore law firm. Angela focuses on clients from the Middle East, and she's going to be joining us today to talk about the process known as probate. Thank you for joining us, Angela.
Thank you, Danielle. It's lovely to have the opportunity to collaborate after knowing each other for many years now. So I'm really happy to be here and look forward to the conversation.
Thank you so much. So shall we jump in? And I guess it might be helpful for you to kick off, Angela, and just maybe explain what is meant by the term probate, if you don't mind.
Of course. So, I mean, really, it's a term that we use more often in the West, I would say. But what it essentially means is the process by which a family prove the sort of legal possession and title to a deceased person's property and possessions and affairs. So when somebody passes away, usually they will own assets and they might also have some liabilities. And probate is the process by which, and it's usually a court-driven process, by which the family, the executors, etc., prove title to those assets. In the West here, it's usually a court-driven process. Unusually in Guernsey, where I'm based in the Channel Islands, as is a church court. So that's sort of a nuance, but in the UK, it would be one of our traditional courts there. And I know that in the Middle East, it tends to be a court-driven process as well. There's a decree or a declaration. I think in Saudi, it is the personal status courts that issue those. So the process is different in every jurisdiction, but there are similarities. But the takeaway point is it's when somebody passes away, it's the process, the formal process by which heirs, etc., prove who owns what, essentially.
Okay, and when would it apply? Is it for every asset somebody has, or are there specific situations for an individual where it would not apply?
That's another great question. Thank you. And it's quite a complicated answer, I suppose, but there are some estates where it wouldn't apply. So again, sort of phraseology wise, we use the term estate, meaning somebody's, what's left after somebody's debts, etc., are paid. So we call that their estate. What passes through the probate process is anything that deceased person is beneficially entitled to at the time of their death. So what we often see globally is families trying to simplify their affairs to make the estate small or smaller. And families can do that by making sure that at the point when somebody passes away, they aren't the legal owner of everything. So one prime example is where a family have built up a business. As you will be really familiar with in the Middle East, you can have a business that is the family's sort of pride and joy, their golden egg asset. It's been in the family for multiple generations, and the family vision is for it to stay that way. The important thing is that the patriarch or matriarch who set up that business, when they pass away, they're not the shareholder of that business. So what families tend to do is they will, and I know that we're going to come on and talk about this in a little bit more detail later, but they will put those shares outside of their personal ownership so that they don't form part of their estate for probate or inheritance purposes. And that way, the shares in the family business aren't part of that process. The business can continue seamlessly in the event of anybody in the family passing away. So really that sort of leads us on to why structuring might be important.
I guess if we Just before we jump onto that, Angela, is it worth just thinking about what would happen if someone doesn't take a structure? Because this is the question I get asked a lot. If I just leave things to kind of like a natural succession, what will happen? Like, what's the process I need to go through? So if you think about, a family that own everything in their personal name, they might have assets in, I don't know, the UK. They might have some shares in a Guernsey company. They might have shares in some other offshore fund. They might have an account in Switzerland. What is the process if it's completely unstructured?
So really good question, and fairly common that a family would have no structure in at least one jurisdiction where they have assets. So what happens then is that it's a cross-border coordinated effort for that family. Often that family will have a trusted advisor, so that might be a lawyer in the UK or somebody in their family office that has been with them for several years, that knows the family inside and out, and is trusted with the family's private affairs. That central point will then coordinate globally for that family, and the assets that are in that deceased person's name will have to go through a probate process. What will happen is, assuming that they've got no will, there will be inquiries made based on that deceased person's records. Every bank statement, every sort of investment portfolio, etc. The family will have to write out to all of these people and gather in data about that person's assets and liabilities, and then the sort of net result of that in each jurisdiction is then reported to a central point, usually the court, and then there will be some sort of inheritance certificate or something issued. So in the UK, for example, if somebody passes away having done no structuring at all, they don't even have a will, we have in the UK what's called the intestacy rules, and those rules govern who gets what. So even though there's no will, you would still have to go to the probate court to get a decree, essentially similar to as you would in the Middle East, as to what the values are, what tax is payable, and who gets what. The tax is an interesting one. In the West, certainly a big disadvantage of not putting your affairs in order and minimizing your estate is that your estate is often taxed to, say, 40%. So the bigger your estate is, the bigger your inheritance tax bill. That's not to say that structures don't attract tax. They do. And at the moment we're seeing quite a sea change in families who are actually very prepared to pay the tax, particularly when they're in a jurisdiction where they're making use of a lot of the public services, for example. Certainly we're seeing next generation seeing a sort of moral compulsion that they are quite happy to pay the tax that's due. But anyway, whether or not you've got a will or a trust, there will be some sort of formal process in any jurisdiction where that family has got a footprint, assets, etc.
So the process would be in every single location. It wouldn't be a single global process. So
No.
Presumably that takes quite a bit of time. You need lawyers to kind of coordinate that. Presumably the costs can rack up quite a lot. And I mean, how long does this take normally, the process?
It depends on the jurisdiction. It depends on the size and complexity of the assets, the speed at which third parties are able to respond, the speed at which the person managing the process works. So, I mean, what we might have is, we quite often have this, is that the executor, the person managing somebody's estate in the process, would be a family member with a full-time job, and actually they're dealing with this administrative process in the evenings or maybe one day at the weekend, and it can take a really long time. Where lawyers are involved, it can be quicker, but for complex large estates that cross several borders, you could be looking at years. you know, especially where there's sort of complicated tax issues or things like that. So probably the take home would be whatever a family can do during their lifetime to help reduce the size of the estate, it reduces the burden on the rest of the family when somebody passes away. So by putting structures in place like trusts, foundations, companies, what you're effectively doing is you're doing the probate process for your family while you're here. And then the output of that is that because you've done a lot of the long yards yourself while you're alive, in the way that you want to, when you pass away, you might, for example, just have the house that you live in, your car, and some bankable assets to live on, and then everything else you might have already structured and dealt with. So your estate might be in one jurisdiction, it might be relatively simple, and you might be talking about a probate process of months, whereas if you don't do that, you're talking about a probate process of several years perhaps. So there are definitely advantages of basically doing the probate process and the steps in relation to it, but while you're here. And we see a lot of families sort of starting on that journey and taking that responsibility.
Yeah, and Angela, what about a will? If someone takes a will rather than a formal structure, which we'll come on to in a minute, how does a will kind of change the probate process that they might have to go through?
So a will would still need to be admitted to probate. But what we would say is, you know, you'd have at one end of the spectrum, you'd have a client that's not structured. At the other end of the spectrum, you'd have a client that's almost completely structured. But then the sort of dipping your toe into starting to do some structuring would be, the first step would be a will. And you would need a will in each jurisdiction where you had assets, and the wills need to talk to each other. So at the top of each will, there's normally a clause that says, I revoke all my previous wills. But where you've got clients that have assets in lots of different places, we need to change the top of each will to say, save us for my will in X country, Y country, Z country. I revoke all previous wills. So the wills need to speak to each other. And the advantage of a will is that it helps a family to override the statutory inheritance shares. So in the UK, we have our intestacy rules, which govern who gets what in what proportions. And a will gives a person the ability to write that themselves. Our intestacy rules are really there in case somebody doesn't do a will. It's slightly different in the Middle East in that your intestacy rules in the Middle East are based on religious principles.
Yeah, so I guess going back to the process then, just to summarize, it would require a will in each location. You couldn't just have kind of a single global will. So for somebody with, you know, many global assets, that could require several different wills that would all need to kind of coordinate. And if there were any changes, several wills that you would need to change. And I think I heard what you said is that it doesn't avoid the probate process. So it might shorten the process, but you would still have to make those applications in each jurisdiction.
That's right. I mean, some families, you can have what we would call a worldwide will. And what happens there would be, so say, for example, somebody had a worldwide will, and then they had maybe a Guernsey or Jersey company, which would be an outlier from the rest of their estate. What you could have in a situation like that is our court in the Channel Islands would allow the worldwide will to be resealed and redealt with in Guernsey, Jersey. So in some situations, you might not necessarily need a standalone will in each place, but it's better to get advice in each jurisdiction as to what would be appropriate and whether a worldwide will could be resealed in that jurisdiction. So there are sort of some nuances, but I think as a rough rule of thumb, wherever a client has assets or a footprint, they need to take advice about how those assets would pass in the event of their death. And if they do have a worldwide will, they need to take legal advice about can that bind that jurisdiction, and would they
Yeah.
need something else? Definitely.
Okay, that's clear. So I guess if we move on to kind of the next level, you mentioned the clients that are at kind of the furthest end of the spectrum in terms of structuring and planning during their lifetime. So if somebody was to structure a trust or a foundation or even a company, what kind of benefits would each of those bring to the probate process, and how would it change or kind of expedite matters if the principal were to pass away in future?
Certainly with trusts and foundations, what you've got there is you're taking the ownership of the shares in that family's business, and you're putting them with a third party. The benefit of that is there are several, but the core benefit of that is that those shares are no longer in the potentially deceased person's estate. So what we see where people don't have a trust, and we've seen this for many years now, is that the patriarch or matriarch, or even if we come down a generation, which is what's happening now, you know, the leaders of the family business, somebody passes away, their shares pass either under the intestacy rules or Sharia rules or their will. What you can end up with is people on the board of the company, lots of new people, if we've got, say, Sharia principals, who have no idea what's going on in the family company. They might not have any appetite to be involved in it, and they might not have the business acumen to add value. So what you can end up with is, you know, a very successful multi-generational family company where there's no structure in place, where previously you've had a very harmonious small board, and then what you get is one or two branches of the family then have new members that come into the board that have no knowledge, information, expertise, but they are coming into the family business. The process of determining who's going to come onto the board or be a shareholder, etc., can take quite a long time. And you also have people that come onto the board that have no idea about the family company, so they can damage the company. They can cause the decision-making process of the company to be hamstrung, slower, change direction, etc. So by not having a structure in place, you can very easily see family business that have been successful for generations, the values start to be eroded, arguments start to creep in, distrust starts to creep in, and very soon you've got a really difficult situation where you might end up in litigation, which again hamstrings the company, slows the process down, reduces value. So a trust or a foundation, by removing the shares in that family business and putting them into a separate structure, you, in the event that the patriarch or matriarch passes away, the ownership of those shares is not interrupted. You know, the probate process doesn't impact at all the sort of administration of the company. So that is a massive factor for a lot of the families that we deal with. Plus sort of the direction of who's getting what and where, having the control over that and the peace of mind that you know where those shares are going, where that value is going while you're alive, rather than sort of leaving it to chance, I think is very high on people's radars for sure.
Okay, and in terms of the process itself, so you're kind of saying that it will ensure succession by putting it in the trust or the foundation, because there'll be no delay or kind of freezing of the business or the shares. Is there any process that, say, a family member would need to worry about if, say, the patriarch did pass away, or would it all be dealt with by the trustee? Is there still going to be a cost, court applications, this kind of thing?
No, absolutely not. So it's a really good question, but what we tend to see happening is the patriarch or matriarch will be aware of the problem of doing nothing. They will start to take legal advice. about the possibility of setting up a trust or a foundation, but that will be a conversation that can have sort of many iterations. It's not normally an initial discussion, the family get comfortable, the trust is set up the next day. It's a sort of exploratory process where we sit down with the family. We often sit down with 2 generations of the family. So now patriarch, matriarch will bring in the managers of the business that are family members. They will bring in the next generation, and we will sit together and agree what the family vision is. So one of the families I act for, they own a bank. So they're 4th generation now, 4 branches. So we've got 16 blocks of family members, but they've all been brought into the conversation since 2008. They all signed up to the fact that they all want the bank to stay within the family. So exit from the bank and from the trust is made really difficult so that the family stay together. And yeah, what we tend to do is we'll sit down with that family and we will map out the family constitution, which is it's not a legal document as such. It's a manual where the family will just agree some core principles. It could be 2 pages long, it could be 60 pages long, but the family will all sign that as a sort of a show of good faith. And then we will set up a trust structure or a foundation structure offshore, which will be run by a trusted intermediary, so a trust company. And but they will be informed by the family charter, family constitution. So the trustee, although a third party, which is necessary for putting the shares outside of a person's estate, they will be guided by and constantly in conversation with the family. So when the patriarch, matriarch pass away, they've still got a relationship with the next generation. Everybody knows what the patriarch, matriarch's vision was. The shares are already with the trustee in the trust. So when patriarch, matriarch pass away, they're not part of the probate process. Everybody knows what the vision is. There's no interruption at all in the running of the company. And, it might not even be a company. It might be a, real estate portfolio or investment portfolio or anything like that. But the longevity of that asset, the sort of administration of that asset just continues and isn't interrupted by or disrupted by the death or incapacity of the family member who owns it effectively. So the advantage is, you've got clarity, you've got control, you've got speed of administration, etc. I would say the only disadvantage to going into a structure, there are probably 2. One would be the cost. So there are fees for setting it up and ongoing fees each year. So the family have to think really carefully about cost, but quite often tax savings and administration of probate costs can neutralize, several times the costs of running the structure. So the setting up and running of the structure can quite often be cost neutral. So I mean that can be a factor. The other factor would be when you have a structure in place, a family will need to engage with the trustee or person running the foundation regularly. So there might be an annual meeting, or if the structures are very, very active, there might be quarterly meetings or monthly meetings, etc. So once the structure is live, there is a process, an administration process of engaging with the people running the structure and ensuring that everything is run in accordance with the family's wishes. And that does take time. It is an investment of time, but it's probably better than the time that the family would spend having done nothing, unpicking what was intended and what was required after the event. I would say that the upfront investment of time of getting everything in place is much easier administration and much clearer than trying to unpick a mess in the event that somebody dies when they haven't done any planning.
Yeah, I would agree. And I think those are really helpful scenarios you've given there as well. Just two things to pick up on from what you've said, I guess. The first being you made a reference to a family constitution or governance document. So have many discussions with clients about this. And I guess your view would be helpful here in terms of whether that as a standalone document is actually binding on the family or whether that needs to be built into a legal document like a trust instrument or company articles. So do you have a view on that?
It's another great and very topical question, actually. So I think certainly in the Kingdom, there was a recent legislative change, which I think might have been last year, which pointed to family constitutions being binding documents. In the West, the position is that the documents aren't legally binding per se, but they are very persuasive, akin to a very robust letter of wishes, which again, not legally binding, but really persuasive. So if a family set up or put in place a family charter, family constitution, memorandum of understanding, call it what you will, letter of wishes, they're all the same thing. If a family put one of those in place and they had, say, a trust structure or not, and it was departed from, it could still be admitted into evidence in the event that there was a dispute. So although not binding per se, it could be admitted into evidence in the event of a dispute, and the court would ask questions about, I see you've agreed to all of this as a family, or I see you've directed the trustee with your vision in this way. Trustee, you've departed from that. Why? What's the explanation? There can be really legitimate explanations. So the family charter might be very old. The next gen might have very different views, or the markets might have changed where, the family were invested in these assets, but actually a completely different direction makes a lot more sense for the family because. So there are circumstances in which it can be legitimate to depart from those things, but certainly we see expressions of faith, family principles. I've got one really interesting family that they spend a lot of time in Dubai, and the patriarch is a creative guy, really successful musician, and but his children are also very creative, but want to do a lot with his image and the brand surrounding him. So when we were looking at their family charter, the patriarch was very keen on sort of traditional type values, and the next generation were really keen to get that sort of make it a very creative document and get their projects and things in there. So it can be a really good way of bringing the family together and actually getting the conversation out on the table and into the open, and inspiring the next generation to participate in the family enterprise and feel part of it and feel enfranchised. But yeah, circling back to your question, in the Middle East, certainly more binding than in the West, but in the West, persuasive at the moment. Not binding, but persuasive, and a really good exercise, I would say, and a really good starting point for the family.
Sure. So I guess to the extent somebody wanted a family charter or document to cover the international assets, and there's certain elements of that they wanted to be legally binding, then they would need to discuss at setup having those elements built in to the trust instrument, which is legally binding. So I guess pros and cons of the document being flexible versus staying true to kind of the intentions of the patriarch or matriarch setting the structure and generating the wealth. Final question I had, so we covered a lot on kind of trusts and foundations, and we've covered the will and what happens if somebody is completely unstructured and leaves it to nature. What about if somebody has structured their wealth via just a simple offshore company? They hold the shares in their own name, all of the assets inside the company. Maybe they have a UK property, maybe they have a Swiss portfolio, maybe they have a portfolio within the GCC. What would the probate process be if that shareholder passed away? Do they have any protections against probate?
Another really good question, and this is a very, very common scenario. So we'll find clients that do have holdcos in place for sort of simplicity, consolidation reasons, but they haven't taken that extra step of putting the shares into a trust or a foundation. In not doing so, the shares would be part of the probate process. So the value of everything underlying the company is potentially subject to the probate process and tax. So it can be a really good stepping stone into structuring. So having an offshore company and a shareholders agreement about what happens with those shares in the event of somebody passing away is a good first step in terms of structuring, because you're directing the sort of who gets what, and maybe putting in there some preemption rights or transfer restrictions. But what you're not doing is guarding against the probate process. So you've sort of taken a step, which is a really positive step. And when I was in Saudi last year, it was quite revealing that a lot of the families hadn't gone much further than that initial step. So there was a holding company in place with the family wealth underneath, and maybe an agreement or shareholders agreement as to what happened with the company with the family shares. But the sort of overlaying structure, the final step, the putting the shares into a trust or a foundation, we hadn't pushed to that level. And going that further step is the step where you take the shares out of somebody's estate for probate. So, I think the explanation for that is, perhaps trusts are not something that come naturally to some families. They want to see what happens with other families before they dip their toe in. Those are conversations that we're starting to have. Some families, so we work for two really big Saudi families in my firm, and they're very, very sophisticated in terms of their structuring. So, not everybody is the same, but a lot of the conversations we were having in Riyadh last year and Jeddah were families had sort of gone that step of having a company, but they hadn't thought about what would happen to the shares in that company in the event that they passed away. So we just really need to push forward with that extra step of the benefits of putting something into trust. I think because putting something into trust, you've got legal fees and administration fees. Clients can sometimes sort of take a step back and be a little bit cautious in terms of the people that are educating about those products are those that are going to benefit from the fees if they're set up. So it can feel a little bit self-serving, but the advantages are what they are.
Right,
So,
I agree. I think people need to do their own research on it as well. And, part of these webinars we're looking to do on the offshore is really to kind of raise awareness on the topics. As you know, the family office ourselves, we don't set up these structures in-house. We will always use a third-party provider. So really our role as an advisor is to kind of guide clients with the education so they can make an informed decision. And I think there maybe is a bit of a lack of education out there in terms of kind of the probate topic. And if I can kind of summarize what you've said through the varying situations, you'll have some people that at, I guess, the start of the spectrum are completely unstructured. They're going to have to go through this probate process, which is going to have cost involved. It's going to take a lot of time. And then I guess you've got people in the middle of the road that might have a will in place. They might have a company which has some benefits, but they're potentially still exposed to this probate process you've just spoken about. And then you will have people at the very advanced end that are thinking about or have set up a trust or a foundation and kind of have this seamless transfer. So I think this has honestly been a really, really helpful introduction to the topic, Angela. So thank you so much for your time. I think we are probably at time here for today's session. So I would say any clients that are listening, if you've got any questions about the topic, please do reach out to your relationship manager. We can also involve Angela for any kind of deeper advice or discussion. And I think we will round off there. Angela, any final words on the topic?
That's great. That summarizes it perfectly. It's been really lovely chatting to you, as always. We're really happy to speak to clients just as a sounding board. And I would always say to clients, when you're thinking of dipping your toe into any of this, as you say, do your research, speak to multiple lawyers, speak to multiple trustees, speak to multiple advisors, gather intelligence, and then take it forward. But just sort of stress test what you're being told by asking, go to a couple of different places and ensure that, all of the messaging rings true, what you're being told about fees and benefits rings true. Involve multiple generations of the family, no surprises, get people involved in the conversation early. But as I say, we're always happy to speak to people and answer any questions. So really delighted to be involved in further discussions as are needed.
Thank you so much. Okay, we'll leave it there. And thank you to everyone watching. Please join in for our next webinar. Thank you.